and I am very happy to call on the Prime Minister. I will try to time keep in chat, but I am not reliable on that, so do keep your own times. And Prime Minister, whenever you're ready. Prime Minister, can we get you?
Sorry, I didn't realize I was muted. Cool. I'm gonna start in 1 second.
Okay.
I think that is all. There we go. Cool. Starting in 3, 2, 1. I'm just going to firstly do characterization as to where we think this is likely to occur. B, then explaining the comparative about how it means that where this fails, so you're likely to get access to another trial. That means that it's likely to be retried. You're more likely to access justice. Thirdly, then explaining to you in those specific cases why it's so important for those individuals to feel like they can't come forward and why this has a signaling effect to that. Firstly, context. Where do we think this applies? I think it applies in cases where one, evidence is often lacking. That is to say that in cases like rape trials, where often it's difficult to acquire evidence because individuals may not come forward within a quick enough time span, or B, there's just incredibly like overwhelming like degree of complex evidence that often juries cannot go through or often feel like there is a moral dubious spot. It's often where they think the defendant is guilty but cannot justify it to like not justify it because they're lacking in evidence. But I also think that there's three reasons why this happens in these cases and like not in other cases. One, evidence, like the case in a lot of cases, it's often obvious. One, evidence collection, i.e., there's often a lot of evidence collected on either side, but they often spend weeks collecting it, which means that often there is a consensus on the outcome of that trial. That's often why trials only take 1 to 2 weeks, because they're either the prosecution know that the defense is likely to have a lot of overwhelming evidence that is likely to mean that they get acquitted or likely to do so. They often dump in a shit ton of money into these researchers. B, often have experts who are willing to do this, and it's often they come to a consensus. But three, it's often just why you see a lot of like deals being done preemptively, but often individuals are willing to take the risk. Two, I think it's internal jury dynamics, i.e., individuals within the jury may just believe strongly that an individual is guilty because a certain amount of evidence points in one direction. On the comparative on our side, I think crucially that often just means that it's in cases where there's no overwhelming evidence, it's often dubious, and there is little to no consensus. Thirdly, individuals often do care about justice, i.e., they want to make sure that individuals are not wrongly put into jail. So often tend to default in those cases to things like using not guilty. But I'll explain now why not guilty is the bad comparative, because of the fact that often they're internalized to believe that justice is good. B, they themselves put themselves in their own position of putting an individual in jail is perceived as an like morally bad thing to do because it removes individuals of their agency. So often project that onto other people. There's three reasons why this changes. One, they know that this means that is still fulfilled when they're fulfilled when it's called like whatever the fuck the motion says, not proven. I think that just means that one, the prosecutors having it like that fulfills those incentives. Would be, I think it just means that prosecutors now have the ability to go to judges and say that I want to have a retrial and specifically go towards that. Note that it said that we had like not proven, which means that there's a reasonable degree of belief that we will be able to access the correct amount of justice or the outcome that the justice system buys into. Because on the comparative, what happens is you go to a judge and they say, but this person was found not guilty. I have a finite amount of time where I can listen to trials, and I'm unwilling to actually engage with this trial, and therefore that doesn't happen. Secondarily, I just think that this just means the prosecutors themselves are actually willing to retry it, because what happens on it like a DA's office is that you go and you want to retry a trial, but you're unwilling to do so because your superiors will not approve of that, specifically because of the fact that they think it's just likely to not be a winning case. Often you're promoted or depromoted based on how successful you are. And I think that this crucially means that it illustrates to other prosecutors who weren't involved in that case that this may be successful, and they're more likely to do so. 3, before like in terms of like petty crimes or this being used willy-nilly, 1, I think if individuals are likely to be using like an application of racist politics, like law and justice, I think this happens on either side. B, I think those type of individuals, if the jury is racist or the law enforcement is racist, then I think they already have incentives or capabilities to do so in that way in status quo, or I can appeal to the biases of the jury. Xiao, go.
So why don't you just change the bar from beyond reasonable doubt to reasonable doubt in your case?
Because I'm fine to do that too. Like, as in the, I'm not sure the trade-off why it's mutually exclusive and cool your CO can't counterprop woo. And it's this house supports, not this house would. You can't either counterprop that either. Cool. Rape cases where they do report and why that's bad. And secondly, where they often do not come forward. 1, where individuals do conform within these cases. 1, I think it's the trauma of the event or the trial in and of itself, through things like cross-examination or things that often are quite damaging towards that individual. Often individuals come forward because they want access to justice and they feel like the harm that was inflicted on them was incredibly wrong. But often what happens is they're found that the person who is accused is found not guilty because 1, there's often a lack of evidence, or B, they just did not have enough time to create that, to acquire that evidence. Specifically, the reason that this is so important though is because 1, when these cases do arise, 1, there's often A, public pressure to get them done and dusted as quickly as possible. B, individuals like within prosecutors often just have an incentive to try get them done. Why therefore they're found not guilty? I think this has a couple of harms. 1, I think it's a psychological harm upon that individual who has already suffered a great deal of trauma. I think that's incredibly difficult for them to do things like function in their daily lives and actively makes their lives worse. 2, I just think they do not cooperate with future investigations on their side, specifically because they are unlikely to believe that they have their interests at heart. 3, I think it signals to other individuals who may be in similar positions that they themselves should not come forward, specifically because they are unlikely to be able to access justice. The thing here is that on our side, it is likely that you are to be found not proven. Why? 1, it's the moral disgust of the act that you are often being described of. Like the news reports of rugby players in Northern Ireland, I forget his name, but it was like everyone in the public sphere knew that this person was guilty, but the jury had a lack of evidence, so could not prosecute this individual. And that often applies to juries too, because they can see that that individual is guilty, and there's a moral disgust there that means that they do want to project it. Because of my prior analysis about how they're conditioned to value justice, not like putting individuals who may be innocent and not beyond reasonable doubt in prison, they are unlikely to do so. But they do choose the option of not proven, specifically because they know that this trial is incredibly complex, and to some degree there is likely to be um, a trial worth pursuing in the future. And I think that just means that 1, you're likely to get more efficacious trials in the future. B, I think it creates an incentive to make sure that prosecutors have the most amount of evidence and are best able to fulfill that case in the status quo. And I think that those individuals will feel more represented. They're likely to feel better, and they're likely to not feel those psychological harms, because to them it feels like they were listened to, even if it was a not guilt, even though it wasn't a guilty verdict. At least it wasn't not guilty, which is so destructive and disregards their feelings. For all of those reasons, OG.
I thank the Prime Minister for that speech. And to open side opposition, I'm happy to call on the Leader of Opposition.
Cool. Can everybody hear me?
Yeah, we can hear you.
Great. Sorry, I'm just going to get my notes in order and then I'll be ready to go. Starting speech in 3, 2, 1. Panel, human beings are fundamentally irrational. It is incredibly difficult for somebody who has a limbic system and who has an amygdala and who has a brain that is fundamentally more geared towards emotion and towards irrational in the moment decisions to make a logical and objective decision. It is for this reason that we have something called the burden of proof within the justice system, because insofar as human beings are irrational, the justice system must be as objective as is possible. We don't contend that it is going to be wholly exclusively objective, but but that is the reason why things like the burden of proof exist. I'm going to talk to you about three things. Firstly, legitimacy. Secondly, the social impact of this, how it happens and why it's bad. And then thirdly, why we think this will specifically be used for vulnerable portions of the population who are already subject to biases that think they are more likely of doing things that are criminal, and why we think that is bad. I'm also just going to like very quickly, I think a lot of, I'm going to clash OG within my speech a lot, because I think that when I explain to you specifically how the justice system and how jury members are likely to operate, it'll become clear to you why Jack doesn't actually connect any of his impacts to, doesn't recognize any of the impacts successfully to explain why they actually happen, and I'll flag that when I do. But I just want to point out that I think that, look, the thing about sexual assault trials, look, I just think that firstly, the reasons that people don't come forward are fundamentally outside of everything that Jack outlines, because it's things to do with the fact that you just think that you won't be believed. You don't want to, actually Jack concedes this when he points out that one of the only real things that prevents people from coming forward is like the trauma of a trial and the trauma of cross-examination. You just don't want to go through that again. That happens on either side of the house. You still have to go through a trial. You are still fundamentally subject to beliefs from society that say that probably this didn't happen, it wasn't that bad. How do you know? How will you be able to prove it? All of those things still exist. We think that for that reason, the actual instances of it being relevant for things like sexual assault trials are fundamentally quite small. But I also just think you're unlikely to get not proven verdicts in these anyway, because note that one of the reasons that it is incredibly hard to get a conviction with sexual assault trials is not only because it is incredibly hard to prove that they happened, but also because the jury is often subject to biases surrounding the fact that they think that people were asking for it. This is the reason. So like in trials, often like the like underwear that women were wearing is used, like, were you drunk? What were you wearing? We think that those things still exist. We think it's unlikely that you'll get a jury that is free of these biases. We think that, look, we think that it's probably unlikely that they actually get the not proven verdict in those instances, but actually we think that even if they do, that's probably still bad. Okay, now moving on to our substantive. Firstly, why we think that this is fundamentally illegitimate. There are several like principles of the justice system, and I'm not going to go through all of them, but I am going to point out the fact that there must be some legal benefit to doing this in order to make it compatible with that justice system. That means the fact that will you actually, if you have a not proven verdict, do you achieve things like retribution? Do you rehabilitate the offender? Do you deter other people? Do you achieve catharsis for the victim? So I think that probably none of those things happen. Obviously, there's no retribution because they're not in prison. There's no rehabilitation because they're just let back into society, and they're actually incredibly unlikely to be rehabilitated in the instances in which they do have actually committed a crime and it can't be proven because of things like the social impact I'll get onto. It's unlikely to be a deterrent because, again, they haven't been put in prison. It won't deter other people from happening, and generally, considering the fact that crimes happen anyway, the justice system is incredibly poor at deterring people in its best case. Also, you probably don't get any kind of catharsis for victims because all that happens is the person that perpetrated the crime against them is still out on the streets, is doing the things that they prosecuted them for in the first place, and it still poses a danger to them. We think that going to jail is so bad, and it is a greater harm to inflict this on somebody, or not even going to jail. Like the reason the burden of proof is so, sorry, ignore that. I've got slightly, basically what this means is that also, look, the thing about the retrials is that the only place that a retrial happens is if more evidence can be produced, because judges decided what is retried based on proof, not based on just a gut feeling that maybe this person actually did it. And if we retry it with the exact same set of evidence, suddenly we'll get a different verdict. Obviously that won't happen. Obviously, unless that evidence happens, that is when you get a retrial. And if the evidence reappears, then that's kind of outside the remit of this debate anyway. So the impact about retrials doesn't happen at all. Okay, so firstly, we think it's illegitimate, but secondly, on the social impact, there is a reason that people have things like guard vetting, things like background checks, things like making sure that the people that they hire, even in their jobs or to work with children, aren't dangerous people. That is because there is a massive amount of stigma surrounding people like criminals. The reason that even if you have an incredibly small, say, drug conviction in the United States, or you have an incredibly small theft conviction, or when you were like an addict and you assaulted somebody because you were like really you assaulted somebody because you had no culpability in that situation, you are still stigmatized. What that means is that even if you are not proven guilty, if it says not proven, that basically says that a bunch of 12 people think morally you're kind of a terrible person, but we don't have enough evidence to put you in prison. We think that that still has a very similar signaling effect to somebody who has a conviction of not guilty. We think that it is incredibly likely that like things like a not proven trial, not proven verdict are incredibly rare. So at the point at which they do happen, it becomes it's like incredibly like, well, it's at the point at which they do happen, it's very well publicized. It also means that like it's probably pretty easy to find out that they had that, because like it's, you know, like if you run a very quick background check and you Google someone, they'll come up when you search their name. I'll move on to why this is bad. I'll take CG quickly though.
Yeah, sure, there is some stigma, but you necessarily have to balance that with people who may necessarily be future victims.
But I genuinely don't understand. I don't think you can prove that there's any benefit to future victims insofar as if this person is somebody who was offended, they are still out in the streets, there is nothing to stop them from offending again. You cannot prove any kind of benefit to future victims at the point at which this person isn't in prison. They're not subject to any kind of rehabilitative measures. They are literally going exactly as free as they would be if they were not guilty, except they are incredibly more likely to be ostracized. They're more likely to be marginalized. Firstly, they go through an incredibly high amount of stress. Secondly, they're significantly less likely to be hired, so they're much more likely to be unemployed, on the poverty line, marginalized and pushed to the end of society and be desperate. Also, they're probably going to lose a lot of their ties to their family and their community because of the stigma surrounding it. So they're more likely to reoffend and hurt future victims. Therefore, any kind of case you bring about future victims just doesn't, your benefits just don't accrue insofar as all of those things are objectively true. So firstly, we just think it's incredibly bad for people. We think this looks like the fact that if you go into a shop that you've gone to every single day, suddenly people treat you harshly, suddenly your family cut off ties with you, you lose your job because they say that you're an unsafe person to have there working. It means that you don't have any money, you can't feed your kids, you can't send your kids to school. We also think that this will be used specifically for vulnerable portions of the population, because literally what this is that there's no actual evidence. So you're just going to base on your gut feeling that you think probably this person of color is more likely to be a criminal and the white person that you're sentencing isn't. We think that that means that it will that the harms that accrue happen to particularly vulnerable portions of the people. Gabby will impact this further, but for all of those reasons, beg you to vote OO.
I thank the Leader of Opposition, and I'm happy to call on the Deputy Prime Minister. Here.
Okay, I'm audible. Just to check if this
Yeah.
bingo even works. It's problematic, but okay. Hold on. Is this better? I think. I hope. Okay. All right, I'll start in 3, 2, 1. Panel, please recognize to the extent to which humans are complex and situations do have many gray areas. I think a justice system that is a binary one that pushes people to act basically on the biases and the irrationalities that OO claims that they have, as I think an inherently, well, unprincipled one, but a very harmful one. What we're going to prove to you, and I'm going to be very clear here, we're not changing the world, we're not saving so many court trials, and we're not making anything innovative, right? What we are doing is to prove to you that in certain instances, because this is quite a big of a lottery, is that when the lottery hits in this one specific way, you get something from the victims or the people that are probably the most important part in this debate. They get nothing on opposition. How am I going to win this? First, I characterize when will this be used and how often? Please realize that juries are completely random and a lottery. You get a mix of individuals with different preferences and experiences that are pushed into making a binary decision when this is not an option. I think these are like based on like random like mixes of people in different courtrooms in status quo, right? So you're going to have individuals biased in different ways, which is problematic, where there isn't a medium ground. The reason why I don't think this is going to be over abused is quite simple. I think most individuals do like binary or certain decisions most of the time. You went to court and you witnessed like everything that happened, and you just want to make a conclusive decision, just leave it behind, you did your thing, you're free to go. This was a difficult experience, but like, yes, I contributed to a man being locked up or free, whatever the fuck, and it was the right choice, path of least resistance. So I think a lot of individuals are still going to default to that. Note that I don't think that 100% of people are going to default to that. I do agree with, that humans are complex, and this is the entire issue with the justice system, because I think the extension of this assumption of people choosing binary decisions is why they're fucked on opening up. Because I think in some instances, there are two types of scenarios. The first one is some individuals are just more likely to lean guilty in these types of scenarios due to personal fears and anxiousness, or they have trust issue when the evidence isn't conclusive, but their gut is telling them, oh man, but if you let him go, like he might fucking do it again. I can feel like this is the type of guy that could actually do it, or these types of guys were, you know, uncomfortable to me, right? Or you were touched by the victim's story a lot, you can find something in her, in yourself, right? And you can sort of relate to her, or like be like afraid for your safety or your friend's safety or whatever. These are impulses that happen in your brain, right? So if the lottery hits an opposition that you have this scenario, and most people, there are just these types of people, you're going to get them locked up. I think the second instance is you might have more people on the jury who will demand really strong evidence to be persuaded that someone is guilty. Maybe they have their own biases and feel like the courts just like to accuse people, you know, they were probably in this position like similar to themselves, or have been angry by like, or think that, you know, the women accuse people or whatever. We need to have a really, really high burden for accused people, or they just might be very principled people and be like, until I have everything on the table, I'm not voting guilty, right? I think these individuals exist as well. If there's more of them, I think they're obviously going to vote not guilty. And even if they, you know, were guilty, but there was no evidence, the victim still feels like shit, and they absolutely failed on opposition. Note that what is crucial then in this round is that humans aren't so binary in 100% of the instances. I think you can share the empathy of a woman crying, but you also don't want to ruin someone's life, right? You want to give them something bad without knowing that you have caused a harm. You have random experiences that shape you, right? You can always want to trust the women, and I can say I'm a woman and god damn it, man, I've had some uncomfortable experiences, but I can also had an experience for which my friend was accused of someone sexually assaulting them and they didn't fucking do it, right? So I can also be a complex person and be like, where it might be the case, it might doesn't, but I want to do something in between to know that I made a right choice for all parties, right? And I think this is the nuance, right? Because in these certain instances in which most people on the jury just, you know, like really want to lock someone, but was still, you know, touched by the story, I feel like in the gut that this person is definitely the one who could have done it. Like, but you still have aware the evidence wasn't there. I think that is when you default to this. I think since we're agnostic to what the correct decision was in all of these hypothetical scenarios, I don't think anyone can prove this. When the lottery hits that humans feel this type of a complex way, they can actually defer to this choice that doesn't exist in the status quo. I think the crucial harm on opposition that in instances, in all the which I described, when the binary system exists, this is the one the biases hit, and this is where the humans are going to resort to one or the other, right? So I think that definitely defeats opening up over the thing they had a case on like principles or retribution or fairness, because statistically, in some instances, in OWO, the binary is going to switch to not getting retribution because you voted someone that was fucking, you know, guilty free, and vice versa, right? I think that we just minimize the amount of instances in which it happens. One, just a random lottery of people's experiences, people on the jury, and how the evidence looks to them hits. And I think this is crucial. Why is this the most important thing? And the closure to victims. I think it's very intuitive from oppositions to come and say, well, you've already been harmed. There's nothing we can do and you just have to live with this, right? I think this is bullshit and quite offensive, right? The worst part of this is, yes, you know you were harmed, right? But you still literally exposed yourself. You were vulnerable to humans you never knew in that fucking jury. You talked about your experience. I think that the only thing that you can possibly give you, if we cannot give you that this person is completely guilty, is to know that we trust you. Because I think these people feel like, oh my God, I've already so vulnerable. They're going to think I'm weak. They're going to think I was a liar, that I was trying to accuse someone who wasn't guilty, right? Or that I failed, right? I think when this is not proven, you can be like, we do feel for you. And we do think that this definitely might have been the case, but we are so, so very sorry that unfortunately the evidence wasn't there. What this gives people is something to cling to, right? It gives them just the feeling that they have not completely wasted like all of their chances, and that it wasn't like these people are going to think that they're, you know, terrible individuals, or that when they go home and talk to their friends and family who know that they've been in court or have been there with them, right? I think it's just slightly better to know that there was some sort of justice in terms of like people do genuinely believe that your story was correct and that you were heard. That is winning. Xiao.
All of the stuff that you analyze suggests that people are going to be more likely to think with their emotions, gut, and instincts. And this is not how we ideally would see people getting thrown in jail or not.
No, Lovro, it's called a complex analysis. So what I did was, because I cannot claim And I don't think no one can in this instance. More people are going to want to lock people up, or more people want to be in cell. I genuinely do think we're all complex. And I think the problem is when the jury is a fucking lottery, no one in this debate can claim what is going to happen. I analyzed all the possible scenarios in which the lottery might happen. What I'm telling you, in some instances in which the complex individuals feel this combination of biases, but on your side are pushed to make a binary decision, that is when in an objective reality exists, you're going to get a misjudged one, right? And I think also you get nothing for these fucking victims. I also not only think this is crucial for some sort of closure, but in the case that you do want to pursue a next trial or you want to go to a mistrial, right? I think it gives you some sort of fire to fight for something. I think it's not proven, but I think you're more likely to go to prosecutors again and feel like if you want to fight this fight, you genuinely can, because someone out there might believe you. And sometimes maybe next time it's going to be different and a lottery is going to hit in a way that it should. But please, panel, at a point where everything really is sometimes a gray area and complex, and everything can happen. If you want to maximize any of the principles that could exist, but also I think just the feeling that people actually got something after their lives were probably ruined, I think it's fair to give them something proposed.
I thank the Deputy Prime Minister. And to conclude opening opposition in the opening half, I'm happy to call on the Deputy Leader of Opposition. I thank the Deputy Leader of Opposition and indeed all of top half, and I'm happy to call on the Member of Government. Hear, hear.
Sorry, can you hear me?
Yes.
Okay. Well, my internet just froze for a second. I hope it's okay. Let's persevere. Okay, POI is in the chat. Assuming I'm still audible. Okay, it's saying my internet connection is stable, so I might turn off my camera, and it might be wise for others to do the same. Sorry about that. Okay, can you just confirm I'm still audible?
Yeah.
Great, thank you. Sorry, my internet shit. Okay. All right, starting in 3, 2, 1. Okay, front half discusses a lot of possible scenarios, but don't explain why these are plausible scenarios or indeed the impacts that follow these. Whilst opening government are correct to point to things like comfort for families, I think everything we're going to bring you will significantly outweigh this, and our case will also respond to much of opening opposition's contentions around minorities. So, but let's firstly get out of the way one annoying thing about what the possible alternatives are. I want to note that mistrials are insufficient in these instances because those are decided on questions of law, not questions of fact. And maybe CO's POI is a red herring, but I would posit that lowering the burden of proof is obviously not an option because that's like a one-size-fits-all approach to a very nuanced issue, and 2, likely to just result in many innocent people going to jail, and that's something that we ought to not, support. So I want to first, in this extension speech, look at what the impact on guilty people is likely to be. Because I think one of the problems with opening government's case is that they seem to assume that people will always get prosecuted at a later stage. But unfortunately, sometimes you just do not collect the sufficient amount of evidence in order to allow that to happen. And therefore, to some extent, I think some of opening government's impact is probably small. But I would say that a verdict of not proven even has a huge amount of value in cases where that person would never get prosecuted later or would never go to jail at a later point in time. And that benefit is very simple. It's a signaling effect to society, which is basically just, maybe you ought to be a bit careful around this person. And I think this is immensely useful in cases like, for example, where someone is accused of sexual assault. It means that a woman can look at that and decide, maybe I ought not, interact with this person or get into a relationship with this person. I would say that on the flip side, it doesn't have quite the stigma that a guilty verdict would have. And therefore it balances that and allows people some opportunities, i.e. this person could probably still get a job. It just means that people can be slightly more cautious around them. And opening opposition, I think, are incapable of balancing this stigma. They just say, it's bad if you have this label over you. Yes, it's maybe not ideal, but I think what we do is we balance that with the fact that people, if there is a fairly reasonable suspicion that a jury had that this person may have committed a crime, even if that evidence is there, I think people ought to be suspicious and they ought to make decisions that they can inform themselves around this. And again, this person is not being locked up. They still have some rights. It's just a signaling to society. So I think this is extremely reasonable in this sort of circumstance. So this material is important because it addresses the scenario of if these people don't get prosecuted later. Now I want to talk about minority groups a little bit more, and I think this material will very nicely engage with opening opposition. I would posit that probably the most significant circumstance where you have a gut feeling and you think that someone is guilty, but you do not have the evidence to prosecute them, is probably in situations where you are biased. Because think very logically about this, right? Where would you just feel that you just have a feeling someone might be guilty? It's probably in circumstances where you've been primed to think that that person has somewhat of a guilty demeanor, or is likely, or you feel in your head that that person might be guilty, right? So in those circumstances, that is a difficult thing for a jury to reconcile. And yes, it is true that they may reconcile that and decide that that person is innocent, but there's a very, very real risk that they decide to overcome those hesitations and decide that that person is guilty because they cannot overcome their emotional bias and the way that they feel about their case. This type of verdict uniquely allows them to reconcile that in their head. They can tell themselves, okay, there is not enough evidence, but I do not have to feel bad that I'm like ignoring my gut instinct about the possibility of that person being guilty. And therefore there might be the possibility that this person can be prosecuted at a later stage, or indeed that society can know that they could be a possible perpetrator. So you can reconcile that better. And the impact of that is just that simply minority groups who are often the most stigmatized in society are less likely to go into prison as a result of this policy. Obviously, opening opposition's point here is that, again, it's bad that more, people of color, etc., might have this additional stigma. I would agree with them, but I just think it is far, far, far worse if you are a person of color, for example, that then goes to jail, because that is your liberty deprived. That is certainly a more significant benefit than perhaps a few more people having a stigma that they otherwise ought not have. Before I continue, what does closing opposition have?
Your argument on safety doesn't make any sense. If a sex offender moves into your neighborhood, you need to have official notification by the government to know that they've moved in. You rely on everyone hearing about these cases and then knowing that they ought to avoid these people, which is extremely imprecise.
Yes, Xiao, it's not a fucking perfect mechanism. No shit, good, well done for pointing that out. The point is that it has some benefit, right? For example, verdicts are often published. They are on the public record. If you have a suspicion that this person might have done this, you have access to that information. It is not a perfect mechanism, but it is a better mechanism that you can offer. So let's now move on to prosecutorial tactics, right? I think, and this is another significant harm in this debate, prosecutors are often desperate to prosecute cases, and there are a few reasons for that. One, often political reasons, for example, when you're re-electing a district attorney, but Lovro often accuses me of only having Western examples, so I'll make sure I have 2 additional ones here. Secondly, sometimes it's your personal career that you feel is on the line, that you have to meet certain KPIs. And 3, often prosecutors are trained to believe in the guilt of people because they, for example, very often work with, for example, victims' families, and they have to see that impact every day. And we think on balance, this makes prosecutors far more desperate to get results. In the worst case scenario, this looks like things like using dirty tactics and working with police to gather dirty evidence. In probably like the best case scenario, it looks like, for example, pressuring people more to take things like plea bargains, which are often more coercive. We think that this resolves that because you don't feel that you have the same time constraints in order to get that verdict. You can take a little bit more time. And if the verdict doesn't quite go your way, you have another opportunity to do that in the future. Both of these prongs of extension are important because, one, we think they often apply and hurt the most vulnerable people in society, which is, I think, a more significant and clear impact than what opening government bring, but it also responds very nicely to opening opposition. I want to finally add one additional thing about the types of cases where this might occur. One very significant one that the front half misses out is when things like DNA evidence and technology just improve with time. The reason that's important is because we think that victims ought to have access to justice, regardless of the arbitrariness of the time period that they happen to be born in. And this gives society and police a mandate to develop those technologies more, because if you now have a mechanism to prosecute people at a later point in time when they might not have been found, guilty earlier, it means you have an incentive to continue to developing those things rather than the alternative. This is a far clearer set of benefits. That's why we're very proud to propose.
I thank the member of government for that speech, and I'm happy to call on the member of opposition.
Just as a quick note, I prefer verbal POIs, so anyone who asks me a POI, please just unmute. The types of circumstance that this policy would take place under are the kinds of instances like the Central Park 5, one in which there was very, very little hard evidence, but self-incriminating confessions were garnered. There was very little basis in a modern justice system to be able to convict them because of the rules that have been created around circumstantial evidence and hearsay. But at the same time, in this world, it would be very likely that they get this not proven verdict. The important implication here is that the sorts of circumstances that we're talking about have very particular sorts of evidence which will lead to this harm. I'm going to talk about this in just a moment. I'm going to address two different ideas in extension. First of all, I'm going to talk about why it is structurally likely that individuals trend towards these not proven verdicts and why that ends up having substantial harms to the justice system and minorities in more depth than opening opposition. Second of all, I want to talk about why this incentivizes terrible prosecution strategies and lawyers' strategies. And lastly, some rebuttal of what we get from the other benches in this debate. To begin with, let's talk about this issue of whether or not this actually leads to people trending towards not proven verdicts. And importantly, while opening opposition talks about all the other incentives like racism, they never directly tackle the reasons from opening government about why it's unlikely to happen, like for instance, duties or feelings of justice or feelings of greater obligations. Here are a couple of reasons why it is structurally the case people are going to trend towards these not proven verdicts. The first thing that I want to identify is that in the vast majority of circumstances, this helps you to toe the line. If, for instance, you have a genuine uncertainty, you feel as if either verdict, guilty or not guilty, wrongs a party. Not guilty wrongs the victim who brought forward the suit or brought forward the claim. Guilty verdicts wrong defendants who might be unfortunately, or who might actually be innocent. This means that in cases of uncertainty, in order for individuals to assuage their guilt in order to feel comfortable, they're going to trend towards not proven verdicts because they feel like it's less of a harm to either party and balances it more fairly. Second of all, I want to observe that in most of these circumstances, we're talking about juries who are making relatively late decisions because the consequences are similarly much smaller as a consequence of the fact that you can go for not proven verdicts. So in circumstances where you've already been in sequestration for 2 weeks and you can't come to a consensus, it's deeply likely that more people are going to try and converge upon a not proven verdict because that is a healthy compromise in which people can actually get a consensus and therefore finish the trial as a whole. Why is this then relevant? This means that all of opening government's arguments about duties of justice are just not true. Individuals are not perfect justice maximizing machines. Instead, there are people with subjective preferences, with guilt, with psychologies that trend towards poor decision making. What is the implication of this argument? The first implication that I just want to point out, and this is huge, is that you get more hung trials. Because now that you have 3 options and many people are going to be defaulting to not proven, you will never get the unanimity which is necessary in order to get a final verdict. Instead, you get split votes, which means that you have to have the trial again in the future. And this happens in perpetuity because of these structural incentives, which means that you massively reduce the amount of prosecutions that do happen. But second of all, in the cases where individuals converge on not proven verdicts, we agree with all the problems that opening opposition notes in terms of why this leads to racial bias. Now, I want to add some additional analysis as to why it is the case this structurally incentivizes police and prosecutors to be terrible as well. Because when you can now get a win from a not proven verdict, this means that you are much more likely to go for dirty tactics on their side of the house because you can now garner things like self-incriminating confessions when there's no lawyer present for a child and still get a relative win through a not proven verdict. This means that prosecutorial discretion is being used to charge Black kids more often for crimes that did occur, but where they aren't sure who the suspect is and they need to find an easy excuse like the Central Park 5. This means that police practices become significantly worse because there are significantly larger benefits from garnering self-incriminating evidence, which typically is not enough to secure a verdict by itself in the modern day. No, thank you. Second of all, I think on a principled level in this argument, you also need to consider the fact that the state is unfairly stamping this verdict upon you, because they might mitigate all the arguments about reputational damage and the impacts by saying this happens on either side of the house. I will note that if this is true, this also mitigates all their arguments about, for instance, sexual assaults or for knowing that offenders are dangerous because you would have already heard it. So if they mitigate us, it goes both ways. But on principle, we still win this clash because we think that there's a moral wrong for states to provide speculation, particularly given the fact that this creates an imbalance between the rights of an individual defendant in the state, where it becomes so much easier to cause some harm to individuals, meaning that the state has significantly more power, creating a chilling effect where people are unwilling to criticize the state in more liberal democracies like Singapore, because there's a high risk in which you get punished for not proven verdicts through the state trying to doctor evidence, and this standard becomes lower. Second of all, let's talk briefly about why this advantages the rich. No thanks. The important thing to note here is that this now makes it so that there's an easy way out. And remember, my framing already proves to you why not proven means that you can move from a guilty verdict to a not proven verdict. The reason why this ends up mattering is because lawyers now specifically employ tactics that attack witnesses and their credibility. In the counterfactual world where you needed some hard evidence, if you didn't have the hard evidence, it just wasn't worth it to go for the character attacks and get these poor reputations for lawyers and their firms. But now that it can actually shift the mentality of individuals towards not proven, it is much more likely they go for aggressive tactics, because now it has a marginal effect on the outcome of the trial, given that people's frames of reference have changed. So it means that there's significantly more significantly more character attacks on witnesses, deterring them from coming forward. Sure.
Yeah, please note that if people are racist, if people really want to be dickheads and really want to win the fucking prosecution because they earn money because it's their job, I think going to employ all of the tactics. And I think that what you're claiming is probably quite irrelevant. In terms of the hung parliaments, the hung thing, like, isn't it probably better on the comparative to actually have it multiple times between the lottery analysis to get the correct one than just be a binary false?
Okay, so the first thing I know is prosecutors aren't racist. They just want wins, which means that they exploit racism. If they can get wins in other ways, they will. If this argument is about juries, obviously there's a way to correct for this. I'm going to talk about appeals and retrials right now because this responds to opening government as well. You can only get a retrial if there's a procedural defect. For instance, the judge made an incorrect direction. We know this is true. It can't be new evidence. Think about the trial of Emmett Till, where the man who lynched him later confessed in an autobiography, but the right of double jeopardy meant that he wasn't able to be prosecuted. However, there are procedural appeals when there's a patently unreasonable decision. So for instance, you make a decision that says this person is not guilty, even though all the evidence trends the other way. But now that, for instance, they can opt into not proven, it's much more difficult to prove that they didn't consider the factors properly, because they say, we weighed the factors, we thought it led to not proven. So it hides procedurally unequal procedures, and that means that you get less retrials and less ability to deal with these problems. So that knocks out opening government and retrials in general. Finally, future victims. This is just a vanishingly small benefit. They need these victims to know about all these high-profile trials and be aware to search them up whenever they meet someone. This is a vanishingly small impact. And in the cases where you don't get prosecutions, you can't impose formal punishments. I'm very, very proud to oppose. Thank you.
I thank the member of opposition, the government whip, and to conclude side opposition debate as a whole, happy to call on the opposition whip.
Hello, can you hear me?
Yeah.
Thank you. I will start very soon. So panel, you all have been in a lot of panels in your debating career. We are people who judge all the time and are experienced with handling these things. See what happens when you have less and way less experienced people who now have a middle way option of being undecided. Basically, this is how they approach any sort of discussion where you need to come up with a definitive, conclusion. Otherwise, this ends up being a hung trial. So this is one of the extensions that we bring in this debate, and this is really important. But I want to first engage with government benches before I continue on weighing what we bring in this debate compared to open opposition and debate as a whole. So recognize that the stigma protection point and the DNA advances point don't work within the legal system, because the info slide already says that there's no retrial. So these are some of the stuff that we have rebutted and they haven't pushed back, so we can consider these things solved. But also when they talk about plea bargains, I would posit that it's more likely that prosecutors will say you either plead guilty or you will still get reputation trashed if you somehow win on their side of the house. But also, given Jason's analysis on how prosecutors think, I don't think that they're going to care about, oh, I got 5 not proven in my career, because it fucking shows bad on them. There was something, but I couldn't dig it out. That's why they have all of the incentives to still, in these cases, prosecute for the guilty sentence. They're not going to just be happy with a non-proven sentence, and it's going to play out badly on them. So in this particular instance, Not a lot of changes for the most vulnerable people who CG want to prioritize, but they don't mechanize. Engaging in opening government, specifically on the sexual offenses type of thing. I think that opening opposition do a good job of saying why there's other problems. They don't necessarily solve the issue. But I want to highlight why we say that this is worse on Gov, because defense particular for what OG outlined, for what their reasons have a reason to go for non-proven. That means in instances of coming out are largely disincentivized, but also one of the most painful trial procedures ever where you have to face your sexual abusers become harder because there are instances where the person is guilty, but not actually guilty and walks away, but also because these trials can be repeated and the person is going to be subpoenaed to witness again. And these are all sorts of difficult things that happen more on their side of house. But also both governments say that people default to binary things and have emotional bias that is problematic. We flip this. We say most people don't want to assume responsibility for their actions. They are likely to take the middle road. But it's also OG's analysis on people being emotional and impulsive, which makes things worse. That's not what a legal system should be like. We agree people are not great in this, but you make it worse because you give more options for them to actually, for their like non-legal, non-objective type of biases and like instances and instincts and guts to take precedence over the clear division of whether a person is guilty or not, right? So just because something is inherently not perfect doesn't mean that with your policies you don't make it worse or exacerbate all of the bad things that can come out of this. Look, we are the only team which engages this debate on the perspective of prosecutors, defenders, and generally the legal precedents this will set. So structural things and not on a case-by-case basis, whether the rich gets acquitted or not, and blah, blah, blah. Look, people will study cases where this worked, apply their strategies to this. It's not only about the jury, it's about people knowing this exists and game theory adjusting. So if this is an option, if I have a third option, I'm going to adjust my strategy as compared to having two options. The impacts of this, with Jason outlines in the extension, being that you have a subset of people who would be guilty now walk away with not proven. But you also have people who would be innocent and are put the burden of them of non-proven. Jason characterizes not from the perspective of we know there are issues with legal system and inherent racism, but how this opens doors given these people's incentives already exist in the status quo. So for example, the comparative is if you agree that there are some racist cops in the United States, if you allow them to do a frisk and search policy, that's going to get worse than if you prosecute them if they do this or you fire them if they do this, right? So it's not about whether people are inherently racist or not. It's about how much checks and balances there are in the system to stop people from doing biases or doing bad things and all sorts of these things. But also recognize that even if you're not sure whether OG proves or like GovBench in general or opposition proves that this increases or decreases cases in this sort of scenario, what we are certain from closing opposition is that there are more hung cases. This is applicable in all situations, whether we characterize the debate better from Gov or all. You get more inconclusive trials and slower justice process. This harms people who can't cope with longer trials and protracted trials a lot, but on the counterfactual benefits those who can. So even if you don't prove this inherent type of thing that rich people are going to get off the hook easier and like poor folks or people who don't have access to like good lawyers, blah, blah, more, it's still the consequence that there are more hung trials that then reverses this impact that we claim as well. So this is another mechanism, even if our first mechanism fails. But also recognize that the POI, which we asked to open government, why don't you just change the bar from being reasonable doubt to reasonable, you know what I mean, beyond reasonable doubt to reasonable doubt? Because they cannot principally weigh this. State is not there to adjudicate based on stigma or infer conclusion from the legal system. Media and community in general will do that and have the right to do that. Even if someone is just accused, that signals that there is a need for it to go to trial. For example, this is the level that state can do. Like even if the person ends up being innocent, you still have stigmatized this person by, pushing him to go to trial because there was some maybe evidence that suggests that they should go to trial. What governments need to defend here is to use legal system at best as a soft power signaling tool that tells we are not sure, but infers more guilty than not. And as much as we prefer not sending innocent people to jail, we prefer government not shaming innocent people too, particularly when the level of guilt that was set before, and this is beyond reasonable doubt, is now watered down. And it's not for other purposes and other like types of cases that we have in the legal system. So this is a big this principle harm that they get on government. But I want to engage with OG now.
The safety signaling can only happen if people somehow find out. People will employ the dirty tactics anyway due to incentives not changing. The benefit that no one can take down a way out is that when all the factors add up, the victims who went to this one trial will feel like they've been understood. Your hung decisions are just more likely to happen on your side when it is a gray area, but there are only two types of votes without a third option.
It's over 20 seconds, but DLO actually took down this because DLO did the weighing of why it's better for victims on their side of the house. I don't think that's the most important thing in this debate. If we prove that for all parties involved, whether it's victims or it's people, having more hung trials is actually something which is worse. And we have 2 minutes of analysis on why there's more hung trials, and you say there's a gray zone. There's already a gray zone in the CSGO, so that's not enough to take this point. But lastly, trust in the legal system. Look, this is also a big harm because people trust the legal system in the status quo because it's definitive, because it's not ambiguous. When trials are longer and perceived as less definite and justice is ambiguous, this leads to people trusting the legal system less. Impacts being less people take part in the legal system, you have more paralegal things like the media or other factors impacting the trial, and you have less reform or people willing to reform. That's why it's CO, I think.
I thank the opposition whip and indeed all speakers. Thank you